Sherry Palmer, and this is Ron Palmer with Fixed Family Courts, and we're here today to go over wrong-headed thinking and best interests in the divorce courts when you are battling over child custody. So a key factor, and probably the primary factor in your case, is going to be best interests of the child. The result of your case is going to be on how you present your case on paper and in person. And usually on paper, that's called pleadings and motions. The approach or strategy that you take will be dependent on how you believe and what you believe to be right. But is what you believe to be right for you and your child going to matter? And what's at stake here is whether you're going to have the rights and the authority to continue to parent in a way that is beneficial for your child after the divorce or separation. The way you present your case, what we call framing, is what's going to make the difference. Every attorney does it. Problem is, they have only a few strategies they use with the same patterned bad results. In order to get different results, you're going to have to reshape the way you might have been taught to believe about roles and responsibilities, and the way you think about the roles and responsibilities in divorce and the government's role in your life after separation and divorce. There's a lot of confusion around best interests of the child and who decides it and when. So let's start with discussing best interests of the child. So Ron, what role would you say that best interest plays in the custody of a child, in divorce and separation, according to the cases that you've researched?
Well, according to the United States Supreme Court, the best interest of the child is not the determining factor for custody, so long as the parents meet the minimum reasonable standards of child care. Beyond that, the parents can put other children's needs before that child, and the parents can even put their own needs before that child. Right? And all the state really can do, legally and constitutionally, is to apply minimum standards across the board that apply the same to everybody. What the states and the courts have actually done over history is because divorce has always been such a negative thing, such a bad thing for all of our history. The courts have felt very free to discriminate against divorcing parents, to discriminate against single parents. So anytime you have parents who aren't in a committed marriage, the state feels that they are totally justified in depriving those parents of any rights they may have at any time for any reason without applying any standard whatsoever. Okay? Now we know from Supreme Court opinions that the rights of parents have nothing at all to do with the marriage. They do not attach from the marriage. They do not derive from the marriage. They are not granted to you by the state when you get married. None of those things happen. Your parental rights are individual rights, and they exist between you and each individual child, and they arise the moment you take responsibility for that child and start to create a relationship with that child. So once you've established your parental rights by creating a relationship with the child and caring for the child, then the rights are yours. They belong to you, and they're vested in you. And no judge can constitutionally just come along and assign those rights to someone else. Anything and everything they do in a divorce court is about depriving, denying your fundamental rights. And they take all kind of liberty in doing this because, again, of the fundamental bias and prejudice against divorced or single parents. Now, when you walk into a divorce court, somehow the courts think that they have all of the rights in the world. The moment one of you requests a divorce, the courts think that triggers them to absolutely and totally take over all of your rights to your child and then to reissue those to whichever parent they prefer. Now, this is where the courts screw up, and this is the angle that you need to go to constitutionally and start saying, wait a minute, this court had no authority under the Constitution, no triggering mechanism to invade your parental rights with your child. Now, why is this? This is because your rights as a parent do not depend on your marriage. Whether the marriage exists or the marriage dissolves is irrelevant to your constitutional rights with your child. So, one of those core constitutional rights is the right to make best interest determinations for your own child and to not have the government second-guessing your decisions about what is best for your child. Only in the most extreme circumstances is the government allowed to come in and override your decisions as a fit parent. And divorce simply is not one of these conditions.